One of the most dangerous jobs in the United States Navy during the Second World War was loading ammunition. Every night at Port Chicago Naval Magazine, north of San Francisco Bay, black enlisted sailors carried bombs, depth charges, and naval shells from rail cars onto Liberty and Victory ships bound for the Pacific. None of them had been trained for this. Not at the Great Lakes Naval Training Station, where most had received their basic instruction. Not at Port Chicago itself. Nowhere. On July 17, 1944, at 10:18 in the evening, the pier at Port Chicago ceased to exist. The blast was estimated at 5,000 tons of TNT. It registered 3.4 on the Richter scale at the University of California, Berkeley. It was felt 125 miles away. 320 people died. The question is not only what caused the explosion, the question is who built the conditions that made it possible, and what the Navy did to the men who refused to go back. In the summer of 1944, the United States Navy was segregated by policy. Black men could serve. They were almost entirely excluded from commissioned officer rank, with only a tiny, newly created exception in 1944, the so-called Golden 13. They could not serve in most combat roles. They were assigned to the positions the Navy classified as support and service: cooking, cleaning, maintenance, and loading. At Port Chicago, loading meant one thing: live naval ordnance. Shells, bombs, and depth charges carried from railcar to pier, lowered into the holds of cargo ships bound for the Pacific Theater. The base had one pier, one long concrete structure extending out into Suisun Bay, with berths on either side for two ships at once. On the night of July 17th, the inboard berth held the SSEA Bryan, a Liberty ship. She had been loading since July 13th. After 4 days, her holds contained approximately 4,600 tons of naval munitions. At the outboard berth, the SS Quinault Victory, a newer Victory ship, was being prepared for loading. The pier was staffed entirely by black enlisted sailors from Division 4 and Division 8. None of them had received formal training on handling explosives. The Navy's own investigation later confirmed this. No such training had been provided at Great Lakes. None had been arranged at Port Chicago. Captain Merrill T. Kinney had taken command of loading operations at Port Chicago in April 1944. What Kinney arranged in place of training was a competition. On the dock office wall, he kept a chalkboard. Every day it displayed the average loading tonnage per hour for each division. Junior officers placed bets on which crew would produce the highest numbers. The pressure to perform moved down the chain of command until it reached the men carrying the shells. One sailor later testified under oath that he was afraid to load ammunition because of officers racing each division to see who put on the most tonnage. He described men threatened with confinement in the brig for failing to keep pace. When sailors raised safety concerns, they were told the munitions were not active and could not detonate. The Coast Guard had published explicit handling instructions for naval ordnance in 1943. At Port Chicago, those instructions were routinely set aside. The loading competition had made speed structurally incompatible with the time those procedures required. The danger at Port Chicago was not hidden, it was organized. At 10:18 in the evening on July 17, 1944, witnesses on shore heard a metallic sound from the direction of the pier. Then, approximately 5 to 7 seconds later, the first explosion. Then a second, and final. The SSEA Bryan and her 4,600 tons of naval munitions detonated. Everything within 1,000 feet of the pier was gone instantly. The pier itself, the dock structures, the rail cars on it, the Bryan, every person on or near it. The SS Quinault Victory at the outboard berth was lifted from the water and thrown approximately 500 feet. She broke apart. The blast registered 3.4 on the Richter scale at the University of California, Berkeley. Its force was estimated at 5,000 tons of TNT equivalent. In San Francisco, 35 miles south, windows shattered. The shock wave reached 125 miles. 320 people died. 390 others were injured. Of the 320 killed, 202 were African American enlisted sailors. That figure, 202 men, at one pier on one night, represented approximately 15% of all African American casualties across the United States Navy for the entire Second World War. Not a battle engagement. Not an enemy attack. A loading pier in California. The cause of the explosion was not determined. The pier was gone. The ships were gone. The physical evidence had been erased by the event itself. What remained was a Navy with 320 dead, a destroyed magazine, and a question it would spend 39 days investigating. The Court of Inquiry convened on July 21, 1944, 4 days after the explosion. Over the following 39 days, it heard testimony from officers, civilian workers, surviving sailors, and technical experts. It examined loading records, safety records, ordnance specifications, and witness accounts. The investigation was extensive. It documented the loading competition. It documented Kinney's chalkboard and the officer betting. It documented the absence of formal explosives training across the entire loading crew. It documented the routine violations of published safety procedures. The inquiry's own judge advocate recorded in writing that the loading of explosives should never be a matter of competition. Then the court cleared the officers who had run the competition. Captain Kinney was exonerated. The junior officers who had placed the bets were cleared. The court identified 6 possible causes: sabotage, defects in the ordnance itself, problems with the ship's steam winches or moorings, rough handling by the loaders, a combination of factors, or causes that simply could not be determined. It could not prove any of them conclusively. Its final language suggested that the most likely explanation involved a mistake made by the enlisted men. The men who had received no training, who had been timed against each other, who had been threatened with punishment for slowing down, who had raised safety concerns and been told the ordnance was inert. Those men were implied to be responsible for the conditions that killed them. The investigation had documented every structural failure that preceded the explosion. It had named the competition. It had noted the safety violations. It had recorded the absence of training. Then it arrived at a conclusion that protected the men who had designed those conditions and distributed the blame to the men who had lived inside them. This is not an accusation of deliberate fabrication. The record does not prove intent. What the record shows is the effect, a formal process with access to all the relevant evidence that cleared those with institutional authority and implied the fault of those without it. The explosion killed 320 people on July 17th. 3 weeks later, survivors of the Port Chicago loading assignment were ordered to resume ammunition handling, this time at Mare Island Naval Shipyard in Vallejo, a few miles across the bay. After the explosion, white officers who had been present at Port Chicago were given leave. Black enlisted sailors were not. No additional safety training was arranged. No revised loading procedures were announced. No cause for the explosion had been identified. The order was to return to the work. On August 9, 1944, 258 black sailors at Mare Island refused to load ammunition. Some described their refusal in terms of fear. Others described it in terms of something harder to name. One of them, Joseph Small, later said in documented accounts that he had never felt ashamed of the decision, that things were not right, and it was his desire to make them right. The Navy responded by informing the men they could be charged with mutiny, a charge that under military law in wartime could carry the death penalty. 208 of the 258 eventually returned to work. They were still court-martialed at summary proceedings, convicted of disobeying orders, and given bad conduct discharges and pay forfeitures. The 50 who held firm were formally charged with mutiny. Under the Navy's own legal code, The charge of mutiny required a concerted effort to usurp, subvert, or override authority. These men had not attempted to take control of the base. They had not threatened officers. They had not organized a takeover. They had declined to load live naval ordnance at a facility whose identical operation, 3 weeks earlier, had killed 320 people, without any indication that the conditions had changed. The general court-martial of the 50 men opened on September 14, 1944. It was held in a Marine barracks on Yerba Buena Island in San Francisco Bay. The 7-member tribunal was led by Rear Admiral Hugo Osterhaus. All 7 members were white. The NAACP dispatched Thurgood Marshall, then serving as the organization's chief legal counsel, as an official observer. Marshall was not lead defense counsel. That role belonged to Navy attorney Gerald Veltman. But Marshall sat through 12 days of the proceedings, took detailed notes, and afterward prepared formal statements challenging what he had witnessed. In the courtroom, Veltman's defense argument was legally precise. He cited the Navy's own code. Mutiny required a concerted effort to usurp or override authority. These men had not tried to seize control of anything. They had refused a dangerous order. The actions, he argued, did not meet the legal standard. On October 24, 1944, Admiral Osterhaus and the 6 other members deliberated for approximately 80 minutes. They returned a verdict of guilty on all counts. Every one of the 50 men was reduced in rank to seaman apprentice. Each received 15 years of hard labor. Each received a dishonorable discharge. Each had his pay revoked entirely. Afterward, Marshall filed a formal press statement. Judge Advocate Coakley had handled the case with prejudice. He later appeared before the Navy's Judge Advocate General to argue that the convictions lacked proper legal foundation. His arguments were not accepted. Most of the 50 men were released to active duty by January 1946, after Japan's surrender. Their original sentences had been reduced. Most eventually received general discharges under honorable conditions rather than dishonorable ones. But the convictions stood. 50 black sailors legally found guilty of mutiny for refusing to return to conditions that had already killed 320 people. What Marshall observed in that courtroom was not a misunderstanding. It was the same logic that had assigned black sailors to load explosives without training. The same logic that had cleared the officers who organized the competition. The same logic that had ordered the survivors back without explanation. Arranged into a legal procedure, producing the conclusion the system required. Port Chicago was a wartime event. The explosion was classified. The trial received limited press coverage. The story of 320 dead at a single California pier, the largest American homefront disaster of the Second World War, did not find its way into the broad narrative of the war that Americans carried forward. The Navy began its formal desegregation process in February 1946. Later accounts indicated that Port Chicago and its aftermath had been among the events that made visible the costs of using racial assignment to fill the most dangerous positions in the service. For the men convicted of mutiny, that institutional shift changed nothing on paper. Freddie Meeks, one of the Port Chicago 50, pursued recognition for decades. In 1999, President Clinton granted him an individual pardon, one man, one record, adjusted, not a collective exoneration. Meeks died in 2003. On July 17, 2024, exactly 80 years after the explosion, the Secretary of the Navy announced the full exoneration of all defendants in the 1944 Port Chicago courts-martial. 256 men in total, across both the mutiny trial and the summary disobedience proceedings that followed the original 258 refusals. The Navy's formal findings used specific language. The courts-martial had been fundamentally unfair, plagued by legal errors, and tainted by racial discrimination. The defendants had been tried together despite conflicting interests. They had been denied a meaningful right to counsel. 80 years. The explosion at Port Chicago did not begin at 10:18 on July 17, 1944. It began in the Navy's structural decision to staff an ammunition pier entirely with black enlisted men, assigned to that duty because of their race, without providing the training the work required. It accelerated in April 1944 when Captain Kinney posted the first tonnage figures on his chalkboard and junior officers began placing bets. It became near certain when Coast Guard safety procedures were set aside, when sailors who raised concerns were threatened with punishment, and when loading live ordnance became a competitive event measured by hourly rate. The Court of Inquiry documented all of this, then cleared the officers who had organized it. The mutiny trial documented all of this, then convicted the men who had refused to repeat it. The 2024 exoneration states it in official language: fundamentally unfair, tainted by racial discrimination, denied meaningful counsel. The mechanism that had built the explosion had also built the prosecution. This is what a layered institutional failure looks like when an institution's internal logic is operating without interruption. Not a conspiracy, not a single bad actor, a series of decisions about who performs the dangerous work, who receives the training for it, who is held responsible when the work kills people, made consistently at multiple levels over time. Port Chicago was not a war casualty. It was the result of a Navy that had organized its most dangerous work around race, then used that same organizational logic to determine who would be blamed when the work exploded. The men convicted of mutiny had refused to prove, a second time, that the conditions at that pier were lethal. They were right. It took 80 years for the Navy to officially agree.